By the way, I encourage people to write in when they see these articles that are preposterous to write some sort of opposing view on them, because we need as many people to respond to this garbage that comes out that's unsubstantiated. Yesterday I thought to myself, why did I agree to speak on anything at the seminar today? Because I got too much going on. But I looked at 2622 and had talked to Rick about it. And obviously I watch the listserv a lot, and I see there's a lot of questions on it over the last couple of years. At this stage, I frankly think that this is one of the more straightforward areas of medical malpractice. So we got a statute that was enacted in 2005, August of 2005, and it's pretty much straightforward. There's a couple of vague things that I'm going to talk about, but I think if you read and follow the 2005 statute, you'll be safe. The statute, of course, applies to any new case filed. So all the other craziness that existed in this statute, the pre-95 statute, the 95 statute, the 98 statute, is all irrelevant at this stage because we have the 2005 statute. So what I want to do is go through it and then open it up to some questions if there are some. As everyone knows, this is the prerequisite to filing a medical malpractice case. To get on my soapbox for a second, when you hear that there is nothing preventing frivolous malpractice cases in Illinois, remind people about something that no one knows about, which is 2622, because all of us that do this know that it's not cheap to get a 2622 report, and probably for the number of cases we look at that we go out and get reviewed by someone that we pay for it and we end up losing that money, we typically and always go forward in these cases with 2622s that are legitimate. So this is a way that frivolous cases are protected in Illinois. What does it require? Well, first it requires, an attorney affidavit, and I'm just going to go through the points that need to be in the affidavit. And frankly, all you need to do is specifically copy the statute. And what it says is that the attorney has consulted with the medical professional who the affiant believes is knowledgeable in the relevant issues of the action. That's one. Two is that the medical professional practiced or has practiced in the last 5 years, or teaches or has taught in the last 5 years in the same area of healthcare or medicine that's at issue. Simple. Three, that medical professional meets the expert standards set forth in paragraph A through D of section 5-8, that's 2501. And if you look that up, those are the standards for testifying. They're relatively vague standards, but obviously, they're standards of this person's knowledgeable in this particular area, has practiced, has taught in it, and knows the issues. All stuff that we should be getting anyway, because if you're going to go get a 2622 report, you better get it from somebody who actually knows what the issues are in the case. Because even if you get by this threshold requirement and you get into the discovery process, if you don't have someone that's going to help you, number one, you're going to lose the case, and more importantly, you're doing a big disservice to your client. So that's three. Four is that the medical professional has reviewed the reports and issues a written report which you attach to the complaint, which simply says it is a reasonable and meritorious reason for bringing the cause. And obviously we'll get into what the report is, because that's where the issues are here. And then five, that you, the attorney, has concluded that there's a reasonable, meritorious reason for bringing this based on what the expert's telling you. Those five things should be identical in every single one of our 2622s. No one, frankly, should have a 2622 attorney affidavit that's any different. It should just mimic the statute, period. Now, on the report itself, the statute's clear. One, you need a separate report for each defendant. So if you got two doctors, you need two reports. Doctor, hospital, you need separate reports. Two, for individual defendants, and the key there obviously is individual defendants, the report must be from a medical professional licensed in the same profession within the same class of license. So that means nurse for nurse, physical therapist for physical therapist. You can't have a doctor issuing a 2622 against a nurse. That's different than what existed previously under some of the 2622 reports. But this statute's clear. For an individual defendant, the license needs to match up. I see a lot of times people asking questions about that, but this particular statute couldn't be clearer, and there's a case right on point about this. For non-individual defendants, the statute says the report must be from a licensed doctor qualified to testify regarding the standard of care applicable in the case. So we, of course, assume that would mean hospitals, physician groups. That's the one issue of this statute that's vague to me. Because what if you sue a hospital for nursing care only, and it doesn't deal with communication? According to the statute, it has to come from a doctor, one, but that doctor's got to be qualified to testify regarding the standard of care. The doctor's not qualified to testify regarding the standard of care against a nurse. So what do you do? What I've done in the past is I've attached two affidavits, one from a doctor and one from a nurse. But I typically would name the nurse anyway because I want to control over the nurse when she's testifying. But it's a vague area that there really is no answer to, but you better take one of those two approaches in order to protect yourself. This area also talks about that you have to identify the profession of the reviewing doctor, his name, address, current license number, and state of licensure. And of course the reasons for why he reaches this opinion. You know, all of these things are very specific that you should be able to follow in every circumstance. One of the confusions that comes in is the fact that I think different counties are handling this disclosure requirement differently. Cook County seems to be following the idea that 2622, the August 2622, August 05, is unconstitutional, so they have not been requiring identification of the expert. A lot of the other counties, however, require the identification. To me, when I go get his 2622, I'm not getting it from someone that I'm not intending to use at trial. To me, I typically don't have a problem with releasing the name. Now, I know you're giving the defense lawyer a start or a head start on checking out your expert, but I'm not planning on switching typically unless something arises, and I'm really certain that this person's going to be the proper expert for this case. So I don't really have a problem with that, and under this statute, I'm not going to take the chance that I'm not following the current law by not releasing the name. But there's clearly a difference in the way the courts are handling it. The federal court, and you'll see in the materials I have, seems to be following Cook County. There's a Westlaw site on it of a case where they're also not requiring, or at least this judge didn't require disclosure of the identity. But I mean, to me, you want to get over this threshold issue, so why take the chance? The other issue that's a little different in the August 2005 version is, what if you can't get a 2622 within the statute, so you have to file the necessary affidavit to get the extension? While the affidavit is pretty much the same, you make sure that you realize that the statute specifically says that there are no 90-day extensions allowed unless the plaintiff's attorney withdraws. So you better make sure that within that 90-day period you get the affidavit, or you're going to have a problem because it does not appear that the court has any discretion to grant you a continuance. The one case that's of more recent vintage, August 2009, it's also in the materials, is this Cookson versus Price case out of the 3rd District. And it's an interesting read because I suppose it's some protection for us to a degree. But what happened here is the plaintiff files against a physical therapy assistant, attaches a 2622 that's from an MD who practices in physical medicine. Defendant files a motion to dismiss after the statute will have run. Plaintiff probably realizes that they got a problem and files a motion to file an amended report. And in fact, he's not really filing an amended report, he's filing a new report because he gets a new expert who's a physical therapy assistant, proper expert under the 2005 statute. The trial court dismisses the case and denies the motion to amend. The appellate court has an interesting and the right manner to analyze this, and basically says, listen, 2622 is to prevent frivolous lawsuits. We know here that this isn't really a frivolous lawsuit because you frankly have two experts who are saying that there's a meritorious reason for bringing the case. So we're going to allow the plaintiff the opportunity to file this, quote, amended 2622 because he's done everything he possibly could. Not something that I would want to rely upon typically in my practice. If you get into the situation, look at this case, but it doesn't give a terribly great analysis on why that would be allowed. It seems like they're just helping out the plaintiff to be equitable. But clearly, it identifies that you better make sure that the 2622 comes from a person in the same class of license as the defendant. But you know, it's not something you want to place faith in terms of going forward with your world. There's a couple other cases cited in there that are interesting reads. One is the Supreme Court case in Ocasek. That does not deal with, although it discusses the August 2005 version of 2622, but what it does deal with is what prior version would apply if we didn't have August of 2005. And it goes through, there's several prior versions of 2622. There's one from 1995 that was enacted and eventually found unconstitutional. There is a reenactment in 1998. And the question is that 1998 version applicable, or is the one prior to 1995 applicable? And that's where I think a lot of the questions, frankly, have arisen in terms of 2622 in our world. Ocasek solves all those problems, and the decision's in August of 2008. And what it simply says, and it's a long decision, it says that the pre-95 statute applies, the one you'll find in your green civil procedure book. And that's, you know, that statute's also relatively clear, does not require identification of the expert. But in the event the LeBron case is upheld and the statute is found unconstitutional, which would include the August 2005 version of 2622, we're going to be back to, under Ocasek, the pre-95 2622 statute. And this is all identified in the materials. You'll see I put the exact statute that will be applicable in the event LeBron is upheld and the Supreme Court finds that statute unconstitutional. Just to end, what I'm going to say is, in this whole 2622 debate, in my humble opinion, you got to err on the side of inclusion. Include more. It's not going to be hurtful to your case and will get you over these ridiculous hurdles that we face for filing a case. It'll also avoid a lot of time on responding to a motion to dismiss that just allows the defense attorney to bill. So that's all I have to say about 622. Does anybody have any questions? Good. Hopefully it'll be an easy area law, that at least for temporarily, that we can deal with when there's a lot of other more difficult areas. And by the way, I love listening to Chip Berry talk, because the one thing that he has of great value to all of us is he worked for so long for the dark side that he understands both sides of the fence and really understands the arguments, which is not something you can read in a book. You have to understand what their mentality is and what they're thinking. So the key with Chip is to impart that on all cases, just not $10, $20 million cases, but on any case, Chip can really identify what these issues are, so I enjoyed it. Thank you.